the appeal of Kession Capital Ltd against KVB Consultants Ltd and others.
Good morning, my lord. My lords and my ladies will know, but I will, out of politeness, say that I appear on behalf of the appellant with the learned friend, Mrs. Lucille Taylor, and my learned friends, Mr. Hugh Sims, King's Counsel, Mr. J. Jagacia, and Ms. Charlotte Mallin-Martin appear for the respondents. Well, the one matter of housekeeping, I hope the court has received a single further authority, a case called Brown and the Secretary of State for the Home Department, which was sent electronically, I think only on Thursday last week, my lady. We are equipped with hard copies.
I don't think I've received it.
I don't think I have either.
I'm very sorry for that.
It happened as of an hour ago.
It is not something that I was planning to deal with in opening the appeal. It is a case in this court in which the case of Boss Holdings, to which my learned friends make peripheral reference in their written case, was further considered. I'm sure the court will tell me when it would be convenient to receive a hard copy.
No, it's not reached the bundle yet, but we'll cause inquiries to be made.
My lord, I'm most grateful, and again, my apologies that it hasn't reached you. So the court will have seen that this case turns on the meaning and effect of Section 39 of the Financial Services and Markets Act. And I'm going to call the act FSMA, which is an ugly word, but it's the abbreviation that everyone uses. I'm also going to refer, I hope consistently, to the authorised person, the principal, as the AP, and the appointed representative as the AR, because it's quite easy to muddle up the representative and the person. And in terms of the regulator, I'm going to call them the FCA. My lords and my ladies will have seen that there are two sets of rules made by the FCA pursuant to the Act, which are mentioned by the parties. And they are the Conduct of Business Sourcebook, which is invariably abbreviated to COBS, and the Supervision Rules, which are invariably abbreviated to SUP. So the specific question is, how is the phrase, quote, the whole or part of business of a prescribed description, which appears in section 39(1)(b), to be interpreted, and how does that interpretation affect the operation of section 39(3), which I shall call the deemed liability subsection, because it is pointed out that it is not absolutely strictly a vicarious liability, as that is usually known in the law. And our case is put on the basis that those questions need to be considered in relation to the whole of the appointed representative regime, which entails looking at companion sections within FSMA and at the rules that I've just mentioned. And we suggest that the court, in general terms, ought to favour a construction which enables the most efficient and effective operation of that regime as a whole. So we take a wide approach to the materials that we say are relevant. And we say that when looking at the regime as a whole and construing it overall, that is going to promote the consumer protection purpose of the regime. We take a slightly different view from the learned friends as to what consumer protection entails, and we particularly seek to resist the idea that consumer protection means what the learned judge at first instance called promiscuously wide liability. My lords, my ladies, we say that, first of all, the natural meaning of the phrase whole or part of permits a limitation as to part to be imposed on the AR's permission by reference to the categorisation of the client with whom it is doing business. And we say that we are supported in that by the fact, as we shall see, that the FCA is entitled to impose restrictions on the AP's own permission by reference to categorisation of client. And we
say the AP then?
The authorised person. So my clients have a permission under Part 4A of the Act, as we all will have seen, and the FCA is entitled to restrict the ambit of my Part 4A permission by reference, amongst other things, to the category of client with whom I am permitted to deal. And we say that if that is right as between the FCA and the AP, the authorised person, then there is no reason why the authorised person cannot restrict the AR's permissions by reference to similar criteria, because we know that the AP, the authorised person, does not need to pass on his permission in the same terms. He can impose a tighter restriction. And we say, and I shall endeavour to pick this up when I come to the Anderson and Sense case in the Court of Appeal, that there are very sound reasons of common sense why this should be so. And we criticise the Court of Appeal, amongst other things, for not accepting that submission, not seeing that those reasons of consumer protection are highly relevant. By contrast, the analysis of the Court of Appeal in the present case goes so far as to say that the AP, the authorised person, may give permission to the appointed representative to conduct business which the AP, the principal, is not itself authorised by the FCA to do. And we say, with the utmost respect to the court below, that that is not common sense. It can't be right. And I should enter a caveat here, make the point that this has been known as the nemo dat argument. It acquired that appellation in the Court of Appeal from the judgment of Lord Justice Sales. I accept that...
Males.
Males.
Since we just spent some time saying never that doesn't work, you alarmed me by saying it's all down to me.
My Lord, I am covered with embarrassment that in my first appearance I should inadvertently have demoted you.
Well, I'm just relieved, because I can imagine the submission you're about to make. Anyway, do proceed and make it.
So we say that it is convenient to borrow the phrase nemo dat as a shorthand for the argument, although we accept that the principle is a principle of the law of sale of goods, and I am not going to seek to draw to the court's attention any authority whereby the principle, as propounded in the law of sale of goods, has, as it were, been fertilised over into another area.
It's not a good analogy for a regulatory scheme.
My lady, with respect to Lord Justice Males, it is not, but it is the way in which the point has been described, and we hope that even if it's not a good analogy, it will be a convenient way of referring to the question.
It may be a convenient label. It may be a convenient label. I wonder whether the point really is not nemo dat at all, but rather the fact that the FCA can limit permission by reference to categories of clients.
Yes. Yes. That is, we say, an absolutely central consideration in the case. But we also say that it is revealing that the Court of Appeal was prepared to countenance the AP being able to purport, as we would say, to grant permission in respect of something that it itself was not permitted by the FCA to do. So there's a point of principle there.
Well, it's not necessarily they could permit them. The point is that they're liable if they do it.
Yes.
They could in their agreement, prohibit them from doing it. And one would think that they would, as they did here. But the question is whether thereby they limit their own liability under Section 39.
Just so, my lady, the question is whether the prohibition is effective to circumscribe the ambit of the deemed liability under 39.
Yes.
But there is the oddity you mentioned, which is without any authority from the FCA to conduct business in relation to that category of client, they would be entitled to outsource regulatory authority effectively to the authorised representative for that category of client.
I'm sorry, my lady, I got slightly lost in the question.
Well, perhaps I'm wrong, so don't worry.
I would have expected there to be a rule binding the authorised person, whether in COBS or elsewhere, that says if you have an appointed representative, you must not permit them to carry out business which you are not yourself permitted to do under your Part 4A permission. I would expect there to be that rule. The question is, and so if the authorised person here had purported to say, oh yes, please sell these investments, please advise retail clients, I would expect that to be a breach of their regulatory requirements, and that would be separate from the question of whether, if they did purport to do that, or whether or not they did, and the appointed representative did advise retail clients, they are liable for it under Section 39. But I'm not sure it's part of the respondent's case that they are allowed by the regulatory regime to permit their their appointed representative to do what they themselves cannot do. That would be an extraordinary situation.
My lady, I would accept that. My criticism here is aimed at the Court of Appeal, who appear to have countenanced that was a possible result.
That's what I understand.
Yes.
I thought, I may be wrong, but I thought in Anderson the Court of Appeal held that it was not open to an authorised person to appoint a representative to carry on business beyond that which the authorised person was authorised by the FCA to conduct.
The Lord is quite right. The Court of Appeal did so hold.
Yeah, and I don't think that's challenged by the respondents as a principle. I haven't read their written case as challenging that. So if that's right, then the question boils down to a question of interpretation, as you said earlier, of whole or part of. Is the sale of, or the provision of investment advice or sale of investment products to retail customers an identifiable part of the overall business?
Yes.
That's paragraph 37.
Thank you.
And just so, my Lord, in Anderson, yes. Well, moving on, just to sketch out our case a little further, we say, as the Court knows, that the objective of consumer protection has got to be broadly considered, and we make a number of points, largely taken from Lord Richard's judgment in Anderson. We make a number of points as to how we say that the regime and in the statute ought to be interpreted to promote consumer protection as we would view it. And to put it in a sentence, we say that Section 39.3, which is all about liability, deals with what happens when things go wrong, but that it is equally important to consider how the statutory regime is set up in an effort to secure, as far as possible, that things go right, that consumers are not misadvised and do not suffer loss. And the final topic and the final criticism we make of the judgment in the Court of Appeal is that it established what we would suggest is a false equivalence between the assessment of client categorization and the assessment of suitability. Because, as the court may have seen, the Court of Appeal said, well, assessment of the nature of the client and assessment of the suitability of the advice is very, very similar. And if it is conceded, as we do concede, that provision of unsuitable advice is, in the Anderson terms, a how, not a what, then the Court of Appeal said, well, so also must client categorisation be. And we have some detailed submissions to make later on as to why that equivalence is not there.
Can you just help me, the paragraph in the Court of Appeal where they make that point of equivalence, just for my note?
Oh, yes. Bear with me a moment.
I think it's 89. Yeah.
If we could just check that, just so that
Yeah.
I know what the target of this comment is.
Yes, it is indeed 18.
Yes, thank you.
So, my lords, I was going to go quickly, if I may, to some of the provisions of the statute.
I should just say we have received Brown.
Has it just come in?
Yeah.
My lord, I'm grateful.
Yeah. Sorry to interrupt you.
So we have a note about the statutory framework which was submitted along with our application for permission to appeal, and the court finds that, I hope, at hearing bundle page 16. And this really gives the court some of the references. The general prohibition that a person may not conduct regulated activities unless authorised or exempt is at section 19. I don't ask you to turn it up, but if it's assistant and note, that's hearing bundle 899. An exempt person is defined at section 417, but the one that we're concerned with, as we all know, here is the appointed representative. At section 5, paragraph 5, sorry, of this note, we point out the difference between the fact that a person who is neither authorised nor exempt, but nonetheless carries on regulated activities, is guilty of a criminal offence, whereas an authorised person acting outside his or her permission is taken to have contravened a requirement imposed by the FCA, and that exposes such a person to regulatory sanction. And my learned friends, I'm sure, will develop this before he launches this afternoon, but they suggest that there's an asymmetry in our submissions, to which we retort, certainly on this point, it's an asymmetry within the statute. It's Parliament who decided that the non-authorised, non-exempt person was guilty of an offence. It was also Parliament who said that the authorised person acting outside permission is not criminally liable but exposed to censure and so forth by the FCA.
So the position as regards an exempt person is what in terms of criminal liability?
If a person is exempt, then he's not in breach of the general prohibition.
Yeah.
So that the question doesn't arise.
But can you be exempt in respect of some things but not others?
Yes, my lady.
Right. So then, my lord,
Yeah,
the
so
question is, if you're exempt for some things, but you do something else which is a regulated activity which is not covered by your exemption, then I think the question is...
Then you are outside the scope of your exemption and liable accordingly, because, as again was said...
But is that a criminal... Then you are committing the criminal offence of against the general prohibition? Yes. Right.
So there's a distinction between an exemption and a permission. So if you act outside your exemption, that is a criminal, as an AP, that's a criminal offence, as I'm understanding what you're saying.
As an AR.
Oh, AR, sorry.
I'm sorry.
Well, as anything,
I'm sorry. Difficult.
Right, that's where I was going wrong. So your answer was directed to an AR acting outside.
Outside the scope of the permission granted to him by the AP.
Right, okay.
And it was observed in Anderson's sense that exemption and liability are coextensive.
So and on the facts of this case, so if an AR who's permitted to sell to professional investors, clients, but not to retail clients, does sell to retail clients, does that AP commit a criminal offence? AR, sorry. Maybe.
My Lord, my answer to that is yes.
Right. Thank you.
Right.
And is that because there are categories of exempted people? Lots of different people are exempted, not just appointed representatives. But is that generally a rule that if you... Is that generally how the statute works? That if you're exempted for a certain category of activity under the Act, if you carry out a regulated activity outside the extent of your exemption, then that's a criminal offence?
That would be my submission, my lady, yes. My lady, the next important section is section 55E, which I think perhaps we should turn up. It's to be found at hearing bundle page 918. And this section was inserted in, as your lordships can see, the ladies can see from the top, in fact, sorry, it's over the page. It was inserted by the Financial Services Act 2012, and it provides at subsection 2, the FCA may give permission for the applicant to carry on the regulated activity or activities to which the application relates, or such of them as may be specified in the permission. And there are explanatory notes to this upon which we rely, and the court will find those at hearing bundle 964. Paragraph 198 of the notes in the middle of the page. New sections 55E and 55F provides that the regulators may grant permission for all the activities applied for, or just some of them, may impose limitations, for example, limitations on the class of consumer to whom the authorised person may provide services.
So before 2012, then, there was no power to limit that. I find that
There was, my lady, but just not in precisely the same terms. At page 916 of the bundle, the court should find the now repealed section 43, which was originally in the Act, and subsection 1 of that section was couched in very broad terms. Part 4 permission may include such requirements as the authority considers appropriate.
Section 43?
Section 43, subsection 1, my lord, on page 9.
Yes, I see. Yes, sorry. May include such requirements. Yes, I see.
Which would, in our submission, include a requirement to refrain from doing something. Pertinently here.
Well,
Yes,
that's what it
it's
says.
subsection 2B.
Yeah.
Yes.
A requirement to refrain from taking specified action.
Yes.
But was there some question about whether that enabled them to limit people, so that limit an authorised person to only giving advice to professional clients?
In other words, my lady is asking, was there some suggestion that under section 43, as it then stood, such a requirement could not be imposed? I'm not
That's
aware
what
there
I'm
was.
asking, yes. Right.
And in fact, one can see, just for completeness, that section 43, the parts at subsection 2 and following did find their way into the Act as it was amended, because at hearing bundle 931 we find 55N, which is entitled Requirements under 55L or 55M further provisions, and the court will see that 1, 2 and 3 mirror the language of section 43.
But in light of the fact that 55E relates to classes of client,
Yes.
those must be referring to some other specified action that must be taken or refrained from.
Yes.
So I'm not sure what the relevance of 59N is. It's headed requirements under section 55L or 55M.
My Lord, I'll point on that as a short one, that 43 was repealed, but the provisions carried over.
I
So
see.
insofar as
I
my
see.
learned friends are suggesting, oh, well, all this is a very new concept,
Right.
and one should not construe the Act as a whole, one should have regard to the fact that 55E was introduced by amendment. We say that's not right, because the essential workings of the statute were very similar. And 55E may cast further light, maybe further detail, but this is not a Boss Holdings situation.
Do you know whether it was the practice of the FCA to impose restrictions prior to the 2012 Act coming into force in respect of different categories of clients?
My Lord, I think it did, but I may have to take instructions on that.
Yeah.
I'm
I mean,
not
that would
aware
give, in practical terms, some indication as to why Section 55E was brought in, whether it was something new or whether it was just a part of a reenactment. Of
My Lord,
certain
I'm wary of, as it were, giving evidence on this.
No, well, right.
But the other pertinent point, I think, for the court to note is that client classifications, retail, professional, eligible counterparty, have, so far as I'm aware, been part of FSMA from the beginning.
Yeah.
And the point of client classification, one of the points of client classification, is that the retail client enjoys a significantly higher level of protection. The retail client is allowed to go to the Ombudsman for compensation. He's allowed to make application to the the FSCS compensation scheme run by the industry. And most importantly, provisions of COBS 9, which are the suitability provisions, designed to secure that the advice is suitable following gathering of information about all sorts of things to do with the client. The provisions of COBS 9 do not apply to professional clients or eligible counterparties.
And that COBS 9 has been in force in one form or another since when? Are you able to tell us?
Lord, I'd have to look at my notes.
Yeah,
I did look this up.
Okay.
The rules were made by the FCA at a fairly early stage.
Let us know at some point.
I will endeavour to do so.
And I'm sorry, I've got another question which is prompted by that. One's aware that in order to be approved, for individuals to be approved to conduct financial services business, they have to go through quite a few hoops, as I understand it, individually. And I think in some cases exams have to be taken and so on. Is there, if you wish to be able to deal with retail clients, are there additional hoops or exams or whatever that the FCA requires?
My Lord, again, we will have to check
Thank
that.
you.
I'm not able to answer that, I'm afraid. I'm on my feet at the moment.
Thank you.
Check that. My Lord, the document I was referring to, our statutory framework document, goes on to consider and set out some of the rules, both as to supervision and as to client classification. But I will pick those up, if I may, slightly further on when I turn to deal with the view of the Court of Appeal that the exercise of supervision and the exercise of assessing suitability were very similar exercises. We say that is not correct. Just before I turn to Anderson.
So, sorry, is this the point about what you said was the equivalence of the...
Yes.
Yes.
And as the court helpfully reminded me, that is Court of Appeal, paragraph 89. And before going into the detail of Anderson, I would ask the court to note the obligation to supervise the agent is, in our submission, a statutory innovation. I have found no case at common law where a third party has been able to sue a principal for harm caused by the agent upon the footing that the principal did not adequately supervise the agent. And we suggest that when one thinks about it, that is hardly surprising, because the common law of agency obviously operates in a very different way. The principal is liable if the agent acts with actual or ostensible authority, and if not, the principal is not liable. And it is as simple as that. And a principal who has given ostensible authority to an agent to do something, the third party then suffers loss. The principal can't turn around to the third party and say, well, true it is there was ostensible authority, but I took reasonable care to make sure this didn't happen. Now, clearly, it may be commercially prudent for a principal to supervise his agents in order to secure they don't get into mischief, which may lead to the principal being liable. But as a legal obligation, we say that would not exist. And so the supervision rules in play in this case are unique. We also ask the court to note why it is that we have this appointed representative regime at all. And we do pick this up in the authorities, but to summarise, first of all, without the appointed representative regime, and upon the assumption that everybody had to be directly authorised, this would cause an enormous amount of work for the FCA. And So the AR regime is desirable because it reduces the workload of the FCA. It also relieves the burden upon a small IFA practice, which would exist if that practice had to be directly authorised by the FCA, because provision of information about systems and management information generally, things of that kind, are required if the entity is to be properly supervised. And a small, without disrespect, high street practice might find that burden expensive, unwieldy, and might therefore not do a very good job of giving its regulator the information the regulator wants. And it is for that reason that the AR regime permits a larger entity, usually known as a network, that's where the word network in the Anderson case comes, and a network employs a number of appointed representatives. It supervises them, leaving them to get on with their own business of dealing with customers. And so it's been said that the supervisory burden, which would otherwise be assumed by the FCA, has been, quote, outsourced, unquote, to the principal or network. And this is, we suggest, in public interest because it enables small IFAs on the high street to continue to exist and to service their customers. And to take a homely example, that means that if we have a consumer in the town of Leyburn in the Yorkshire Dales, and there is a high street practitioner who is a member of a network and therefore supervised by an authorised person, our customer can walk down the high street and obtain the necessary advice, rather than having to take 2 buses into the middle of Leeds, which is the closest city, as would be the case if there were no high street IFAs.
Are you going to come to the question of whether, I know the authorisation under Part 4A is a public document, anybody can check
Yes.
on the FCA's website the scope of the authorisation granted.
Yes.
But are the terms of the appointed representative agreement between the principal and the representative, is that also a public document, or is there anything that somebody can look at on the web to check what the permission granted by the principal to the representative is? No.
The only way in which that could be done would be if the customer, seeing, because it's always on the note paper, for example, on the footer, seeing that XY IFA is authorised by AB, the principal, would be to get in touch with the principal and say, look, is this IFA authorised to sell this to me as a retail client?
I did look at the client letter, which is at page 265 in the bundle, which it does indeed have the footer to which you refer, but which is very general. But in the body of the letter, it does say that it, that's the firm, is, however, authorised to conduct certain financial business as per the footer detailed below and the documentation attached. Now, I'm not quite sure whether we have the documentation attached, because the documentation that follows in the bundle concerns Kession. Concerns Kession rather than the appointed representative. But I mean, clearly the footer really doesn't tell you very much at all, because it simply says that it is an appointed representative of Kession. But maybe the documentation attached provided the potential or actual client with some more information. I don't know.
That might be so, my lord. There is a reference on page 267 under the heading Standards. Final paragraph of that section, if the court has it. If you have exhausted our internal complaints procedure and still aren't happy, then we can refer you on to our compliance people, which is Kession Capital Ltd, and the details can be found below. Now, I accept that...
Well, that's all to do with complaints. I think
Yes.
what my lady was asking is, well, if I'm going to deal with this firm, can I find out what they are permitted to do?
My lord, I accept that. So it's not a full answer by any means to my lady's point, but it does demonstrate that there is a little more in this letter than merely the disclosure in the footer.
And then
Well, there is, because there's the documentation attached, but we don't have it.
Which we do not have.
No.
what's 269? Was that attached or was that separate?
269 is a printout from the Financial Services Register.
Okay, but wasn't attached.
Well, it couldn't have been related for the simple reason, and I'm not trying to be a smart aleck here, but for the simple reason that its date is the 27th.
Well, it wouldn't help anyway, because it concerns Kession, which is the authorised person, rather than it doesn't concern the appointed representative.
Yes.
No, but that's the person they're saying you should contact to find out what the authority is, isn't it?
No, I don't think so, but I may be wrong.
Well, lady, I don't think I put it as high as they're saying you should contact. It's someone they could contact, whose role is made plain. And although I accept entirely my Lord Richard's point that the part of the text to which I drew attention is in the context of complaints, so it might be said it's too late, but at least one has reference to Kession in that introduction.
We do, but I mean, my simple point is that on page 265 it says we're authorised to conduct financial business as per the footer and the documentation attached. So you go to the documentation attached, one assumes, to get a bit more detail than we see in the footer.
Yes, but
That's the point.
We do not know.
Yeah, I mean, it does say a couple of paragraphs down that their business is to bring property development opportunities to professional investors such as yourself. So that's a sort of, but it's not saying if you are a retail customer, do not read any further, put this letter in the bin or whatever. It's not necessarily saying we're limited to that, but yeah.
Well, you know that professional investors capitalised
Yeah.
does not, in my submission, mean very much the person in the street. Their reaction to that would be, well, am I a professional investor? How do I know? And for that purpose, of course, they might choose to talk to Kession, but equally I accept they might not. So, well, to summarise here, my Lord Richards is right that we do not have whatever was attached to this. Lady Rose is right that what follows at 269 is from the register. I was making a point because it is relevant to something I want to say a little later, to note the date of the printout, which is the 7th of October 2022, which is to say between 6 and 7 years after the events with which we are concerned. This is what, however, the respondents chose to put before the court, it being their application for summary judgment, and it is also relevant in this connection to note that my clients were not professionally represented during the preparation for the hearing before Mr. Stanley, King's Counsel, and I appeared on their behalf, instructed by advocate, at pretty short notice, as the learned friends note in their case. My skeleton was delivered, I think, the day before the hearing.
But it must be within their knowledge what their authorisation covered at the time they entered into the appointed representative agreement.
That's right, my lady. And
It still seems to be rather mysterious according to the judgments below.
well, if we can deal with that head on, the appointed representative agreement the lady will find at page 229. Page 231, introduction, paragraph B. The AR has agreed to advise on and arrange deals in designated investments for professional clients and eligible counterparties. The AR will not advise on and arrange deals for retail clients. And we find this reiterated at page 235 of the hearing bundle under the definition of relevant business. And relevant business, starting at the top, means regulated activities which the AR is permitted to carry out under this agreement, which are subject to the limitations of the appointors, that's Kession's, Part 4 permission as detailed in Schedule 5. And then, omitting the next paragraph, we see, and I won't read it out, but we see the distinction between retail clients, with which the agreement does not permit the appointed representative to deal, and other sorts of clients who it does permit them to deal with. And Schedule 5, as the court will have noted, is about the appointor's Part 4 permission, i.e. what Kession, as authorised person, was able to do at the time of this agreement. And without reading it all out...
What page do we find that?
252, my Lord.
Thank you.
The court will see that under each activity name, amongst other things, there is a paragraph headed customer type, and there is no mention under any of these customer types of a retail client. And this being a contemporaneous document, i.e. contemporaneous with the commencement of the AR relationship, and therefore the commencement of the advice given by JHM on my client's behalf, we suggest this is good evidence of actually what our Part 4A permission said at the time. But we accept that the position evidentially is unclear, because I can look at this and urge the court that it is a document close in time to the advice which was given. Learned friends rely on a printout several years after the event. And so, in summary, and it's in our written case of paragraph 11, we describe the evidential position here as somewhat unclear. So, my lords, I have been, as it were, promising for some time to come to the Court of Appeal decision in Anderson. I was proposing, if I may, actually to take this from the quotation in our written case, although I'm happy to turn up the authority. But it's a long passage which we quote extensively and fully, starting at hearing bundle page 91, from Lord Richard's judgment in the Court of Appeal in that case. It was the only substantive judgment given. Lord Justice Hamblin, as he then was, and Mr. Justice Snowden, as he then was, concurred with what is said here. And my lords, to take it up at perhaps paragraph 32, my lord said this: second, the AR must be someone for whose activities in carrying on the whole or part of that business, the authorised person has accepted responsibility in writing. And then a number of points were, as it were, unpacked from that. First of all, acceptance must be in writing. In order to determine the extent of the acceptance of responsibility, it would be necessary to refer to the terms of the document by which the authorised person accepts responsibility. And we say that that is a theme in the authorities. It was in fact picked up, as we shall see later on in this quotation. It was picking up something that Mr. Justice Jacobs, who was the trial judge in Anderson, had said. And we say this is important because there is a focus, and we say correct focus, upon the terms of the document between the AP and the AR as being central to the concept of what responsibility was accepted. It derives from the contract as its primary source. And that is why, in my submission, my Lord went on to say this, at paragraph 32, the words "the business" refer back to the business of a prescribed description in section 39(1)(a). The words "the whole," and I omit the next few words, the words "of the whole or part" demonstrate that acceptance of responsibility need not relate to all activity that could fall within the generic type of business described in the AR regulations and specified in the agreement. The acceptance of responsibility may relate to part only of such business, as stated in the acceptance. And I omit for the moment, if I may, the next paragraph, at paragraph 34. The scheme of section 39(1) is thus clear. An AR is an exempt person only to the extent that an authorised person has accepted responsibility for the business to be carried on by the AR. If an authorised person has accepted responsibility for only part of a category of business, the AR will be exempt only in respect of that part. This makes sense. Acceptance of responsibility is the equivalent of authorisation. And I emphasise those last words because we say it shows the commonality of the idea of accepting responsibility or giving permission. They are essentially the same thing. And we say that supports our submission that if the FCA is permitted to say to the authorised person, you have authority to do this, but you must not advise retail clients, then it follows as a matter of principle that an authorised person ought to be able to say that to the appointed representative. And in the next following paragraphs, the Court of Appeal rejected the submission that the permission given to the AR must relate to the whole of a generic part of the business. And they also rejected the submission, this is paragraph 37. My learned friend, Mr. Sims, was in that case suggesting that the reason for the words whole or part of was to enable the appointed representative to act for more than one principle. And the Lord Richard said, well, I agree with that, whilst I accept the words whole or part of, this is about 4 lines from the bottom of the page, whole or part of facilitate the involvement of more than one authorised person with the same AR. I do not see the basis for restricting the clear and unqualified words of section 39(1) to this situation. And turning the page, Lords and Ladies, at the top of the next page, page 93 of our bundle, we have this upon which we strongly rely. The Lord said this: it may make perfect sense to limit an AR to a partial exemption, having regard to the breadth and depth the expertise of that AR, or indeed of the authorised person. And respectfully, we say that that is a very pertinent observation, and one that supports the objective of consumer protection. For this reason, that the authorised person, the principal may look at an AR who comes to it seeking appointment as such, and any competent, reasonable, authorised person will do what's commonly called the due diligence. He will look at what the systems are, experience of the advisors who are appointed, so on and so forth. And he may say, having conducted those inquiries, well, I would be happy for you to deal with professional clients, eligible counterparties, but I am not satisfied, for example, that your advisors have the necessary experience with retail clients, and I do not wish you to deal with such clients. And if a limitation of that character, i.e. you must not advise retail clients, is imposed, that is an important part of consumer protection, and it is responsible behaviour, of course, on behalf of the authorised person. Equally, the appointed representative may, so to speak, make his pitch to the authorised person for appointment as AR and say, look, I've got this tremendous book of professional clients, and I'd like to market to them under the aegis of authorisation by you, appointment by you. But the authorised person might say, well, actually, I run a business, a network, which concentrates on retail clients. I have no experience of supervising people who advise professional clients or eligible counterparties, and therefore I do not think that I can take you on as an appointed representative because I lack the experience properly to supervise you. And so that is a demonstration in our submission of why the demarcation or restriction upon a permission in terms of client type is sensible and promotes the objective of consumer protection.
Can I ask, what would happen to the AP's authorisation if they don't restrict the activities of the AR, so they can approach retail customers as well as professional customers, and it turns out that the AR commits various regulatory breaches in approaching the retail customers, let's say, and that emerges? Is the AP's authorisation then going to be at risk because they are responsible in some sense for what has happened in relation to the regulatory breaches in relation to the retail customers?
The answer to that is yes, my lord, but it would depend upon the view that the FCA took.
Right.
The FCA would be likely, in the event that it discovered significant consumer detriment, that is to say lots of retail clients complaining, they would be likely to look into the matter, and they have a range of powers available to them.
But the important point is that the AP is genuinely taking the risk, the regulatory risk of how its AR performs in various ways, and may for that reason have quite a strong interest to limit them and say don't deal with retail customers.
Yes, I'm not for a moment suggesting, my lord, that this is a matter of pure altruism.
No, I just wanted to see how it fitted together.
And this is, of course, part of the overarching submission we make, that one has to see how all these bits fit together.
Yeah, okay, thank you.
Can I ask another question? It may be that you come to this later, but I'd be interested in how the remuneration works as between the appointed representative and the principal, do they get a
My lady, I can answer.
percentage of the business, or how?
What tends to happen, my lady, is that a flat fee is charged. Although it is possible to have a fee sharing as well. My lady, in this case...
So the principal charges the appointed representative a flat fee per year or per quarter or something for being the appointed representative?
Yes, but one has encountered agreements in which the remuneration of the AP has been on a percentage of what the AR makes. My lady, it might assist, in fact, and we can do this very quickly, if you would kindly look at page 242 of the hearing bible, which I hope at the top, paragraph 5, fees and costs.
This is
This
the
is the ARA.
Yes. 5.1.
242.
The AR shall make such payments to the appointor, whether of fees, shares of commission, or otherwise. So that addresses my lady's first point. And in fact, what was agreed here, you can find at page 249 in Schedule 2. And the court will see fees payable pursuant to clause 5, AR fee and payment terms 2,500 plus VAT minimum, so on and so forth.
What's a CF30?
Customer facing. It's one of the specified functions which are these words set up by the FCA in order to categorise the functions of various persons who either advise or are in managerial positions in the industry.
That's a person.
Yeah.
That's a person. Is it the CF30?
Yes, that'll be somebody employed probably by the AR, I think, or possibly the AP. I'm sorry, my lady. I'm sorry to be imprecise about that, but it's a very long list.
I was just wondering how the money worked, and is there, just a sort of further question, is there some kind of record reporting from the appointed representative to the principal as to what they've been doing or what deals they've arranged or who they've, under the agreement, who they've advised?
That would almost invariably be the case, and there are also regular compliance audits. That's a requirement. We've got those in the bundle, page 293. I don't want to read through this, but the court may care to consult it at leisure. But it's compliance audit, file review, and Lords and Ladies will see that in fact my clients outsourced this review to a specialist firm, which is quite common, and it was undertaken by that third party. So there is a check. The other point, well, two more points before I leave Anderson. The first is that the court may have gleaned, and Lord Richards probably remembers,
Don't bank on it.
that the relevant limitation on the magnificently ill-named Midas, who were the rogue advisor, was that they should do all business through, quote, a company agency. which was understandably an arrangement that the Sense network had with a product provider, so that they might have a company agency with the Scottish Widows and with Aviva, but not with Standard Life. And the purpose of this is quite important, because the reason that Sense imposed that requirement was that company agency business involved the commission all being paid to Sense, because the parties to the agency were the Sense and the provider. Sense could therefore see what the income stream was and where it was coming from. And Sense's auditing system was to require the appointed representative to produce its bank accounts periodically, and there would be a reconciliation. And Sense's idea there was that this would be a good way of supervising, a good part of a supervisory system, because it would secure, as best possible, that business was not being done off the books, so to speak. Now, in fact, that was evaded on the facts of that case, because the money went into a bank account which had a name very similar to Midas, so the clients did not suspect, but the bank account was a secret account run by the principal fraudster, and so no money went through the account that Sense demanded to see the statements for. But I get into that detail because that was a restriction, company agency, which Sense put in place in order to assist its compliance. And it's an example of the general point that I was making earlier, that a restriction within the AR agreement may be calculated and designed to enable the AP more successfully and efficiently to fulfill its supervisory responsibilities, and that is part of my how do we make this go right point. If there is a restriction of that kind, and if it is faithfully observed, then if we had an IFO firm that had 4 advisors, and one of them was doing illicit business but putting it through the firm's bank account, then a competent supervisor in the position of Sense in this case would say, well, what's all this about? And that promotes, we say, consumer protection. And the last point to take from my Lord's judgment in Anderson is the famous what versus, or the now famous what versus how distinction. And effectively, the point is simple. If a restriction is about what business can be done, then it is effective to circumscribe the permission under and prevent liability arising under 39.3. But if it is a how, then it is not effective in that manner. And it's important in our submission to understand where this actually came from in terms of the authorities. And sorry to break the furniture. It comes from a case called Ovcharenko, which was a decision of His Honour Judge Waxman, Queen's Counsel, as he then was. My Lords may have read it, but I can turn it up if it would help. But the argument that was being put to the learned judge was, if I may say so, ambitious, because the second defendant, who was the principal, was suggesting that it had entered into an AR agreement, appointed the other defendant as its representative, and the claimant said, well, we have been badly advised by your representative, and we're coming after you. To which the attempted response by the authorised person was, but I'm not responsible because I made it conditions of the agreement that the appointed representative should do everything properly, should do it with reasonable care and skill and in compliance with COBS and so on and so forth. To which, of course, the answer is, well, if that be right, then Section 39 is denuded of any content whatever, because in order for the authorised person to be, so to speak, in the firing line under 39, it's necessary to show that there has been a failure on behalf of the appointed representative that leads to liability. So the argument goes around in circles. And that can't be right. So we say that the importance of the what versus how distinction, as articulated in Anderson, is it provides a sensible dividing line or principle between the absurdly wide proposition that was contended for in Ovcharenko and an important and principled position, which is that for the reasons we have given, one ought to be able to delineate by means of an intelligible and clear restriction upon what the appointed representative is allowed to do. And we build on that to some extent in two ways. First is that we say that, by contrast to a company agency in Anderson, which was effective, nobody's asking this court to say that Anderson is wrong in that way, or in any way at all. Company agency is effective. When one looks more deeply into it, for the reasons I've tried to explain, there was a good compliance reason for that. Retail clients and other sorts of clients, we say, first of all, are well-known animals in this jungle. They've been there for a long time. They're clearly defined. It's not going to put the appointed representative in any difficulty in ascertaining what sort of client animal he or she has before them. And there's a more obvious consumer protection argument in favour of permitting one to differentiate by reference to the class of the client, which is, as I alluded to earlier, that the retail client enjoys a significant degree of protection which the other sorts of client do not. If the court would just give me a moment. Well, there's a further point in connection with the what and how. We posit a situation in which the AR is not permitted to advise the retail client, but does so. And as it happens, the advisor, who may have experience in dealing with retail clients, gets it right. He or she gives advice to the retail client, which is entirely suitable. The product is then purchased and it's suitable and it performs well. But, so all the hows have been correctly performed by our advisor. But the advisor, in the circumstances we posit, where there was a restriction against retail clients, would be acting outside his or her permission. Now, true it is that in those circumstances there would be no claim, because on my hypothesis the client does not suffer a loss, but it would not make a difference to the technical conclusion that the AR had acted outside his or her permission.
And had therefore acted outside their exemption and therefore committed an offence?
That is what I would say, my lady, but I needn't go that far. My point is that if we're trying to distinguish between what and how, my example there gives us a hypothetical case where the how has all been perfectly conducted or acceptably conducted, but the AR remains theoretically, technically outside the permission, and that shows you that the question of permission in this circumstance is a what. And that's a point that was made to both the courts below that, as far as I can see, doesn't find its way into the judgments. We do take also the point that if my learned friends are right and Anna's has been correct, and you can impose effective restriction on with whom the AR should do business, i.e. somebody in sense within the accompanying agency, it seems a little curious that if my learned friends are right, you cannot impose a restriction on the type of client.
Sorry, if you can impose a restriction on the...
On the product provider, that you can't impose a restriction on the type of client.
Well, you can impose the restriction, I mean, as a matter of contract.
Yes, but why should it be effective for Section 39?
Yeah, that's the point there.
Yes. Well, I'm sorry, that wasn't very well expressed on my part.
Yeah.
I mean, you could, suppose you imposed a restriction that you're not allowed to sell anything to a customer where the price of it is less than £50,000, say. That might, one would think, effectively limit it to professional clients. But then I wonder whether the respondents would say whether that's a what or a how. Or what would you say? Is that a
My lord, lady, if there were a minimum price, that would be a what?
That would be?
A what? Because it's got nothing to do with taking steps to secure suitability, taking steps to look around the market for different products. That is a bright line distinction which is easy to operate and which may have a helpful consequence. I think my lady's question leads to this point, which is that it can be assumed that someone who is wanting to invest more than figure X, whatever figure X might be chosen to be, would be more sophisticated than if the limitation were half X.
But, I mean, is that a restriction that finds any place in the regulatory regime which we have? I mean, does the FCA ever impose on an authorised person a restriction not to sell products for more than £50,000 or pounds X?
My lord, I'll take some instructions about that. The answer is that
I mean, it's a pretty imperfect proxy for professional as opposed to retail investors. Yes. I mean, there must be plenty of retail investors who do spend more than £50,000 on a product. I mean, there comes a point, I agree, where, but it would be a rather blunt way of doing it. But more importantly, unless it finds a place in the regulatory regime, I think that I'm not sure whether the what-how distinction is really relevant.
No, and we would submit that again, going back to what we suggest, which is classification of clients, is a what, not a how. That is a finer and more delicate instrument, because if you're a retail client, you have, as I mentioned earlier, the benefits of COBS 9 applying to you and so on.
Yeah.
Turning back to what I'm afraid, going to call the name ODAT point for short, although I appreciate its imperfection. I've made the point that the terms of the permission as they stood when this advice was given are uncertain on the evidence.
The terms of the authorisation.
In terms of my client's authorisation, as recited in Schedule 5 to the ARA, which I have shown to the court. But that is a point on the facts. The point of principle is that we say, as I have submitted, that you can't sensibly construe Section 39 to mean that the authorised person can pass on a permission which he or she does not have. And this has, I think, been mentioned, but for the court's note, because this is not, I think, a passage in Anderson that we have reproduced in our principal case. At paragraph 28, this is the hearing bundle.
382.
I'm grateful, my lady, in paragraph 28 itself.
Oh, I'm sorry, I missed the page, sorry.
382.
382, yes, paragraph 28, I'm grateful, my lady.
Thank you.
Towards the bottom of the page, Mr. Sims expanded on this last point before us by submitting that under Section 39, a principal has responsibility for the activities of its AR in carrying on of any regulated activity falling within one or more of the prescribed business activities within the AR regulations, which the principal is itself authorised to carry on. And that seems more or less to have been assumed in Anderson. I'm sure my learned friend Mr. Sims will let me know if his recollection differs, but I don't think we debated that. And the final piece of support.
And the publicly available register would show if there was a limitation on the authorised persons, Part 4A permission saying that they cannot deal with retail clients.
So in that rather convenient case, perhaps, one could see, if one consulted that register in relation to the authorised person, one could, if one were a client of some sophistication, say, well, perhaps not a great deal of sophistication. How on earth can this be? I consider myself to be a retail investor, but the people who are supposed to be supervising, people who I'm told are the party to whom I could look for compensation, they themselves are not authorised to deal with such as me. How can that be? And I was just going to complete this section, if I may, by asking the court to turn up hearing bundle page 962.
960.
962. My lord, this should be the explanatory notes to FSMA, and the extract relates to section 39. And at paragraph 94, we can read this. Any regulated activities carried on by the representative in accordance with such an arrangement are the responsibility of the principal, who must therefore have permission for all the regulated activities they carry on. So that's why we suggest that insofar as the Court of Appeal reasoned to the contrary, they were wrong. So this brings me to, I think, the penultimate main point that I wanted to make, which is the equivalence which the Court of Appeal perceived between assessment of suitability and assessment of the categorization of a client. And
So this is the famous paragraph 89 again?
Yeah.
Is that right? Yeah.
Yes. My Lord, obviously I would say it's infamous, but that's a matter of taste. And we discussed this in our written case, commencing at paragraph 21 of that document, which is hearing bundle 95. Sorry, in fact, perhaps I may take this all of a piece, because I make a separate point about supervision, the Court of Appeal said about it. But if we can start and take this block of rules together, and then I'll come back to what we say about it. The first rule we asked the Court to notice, and it's quoted at paragraph 41 of that case, is SUP, Supervision Rules, 241A, G, and I should just pause there to say that by way of a further trap for the unwary reader, these rules are divided between rules which have an R at the end, obviously. G means guidance. Guidance is relevant to be considered as part of the assessment of whether one is in breach of a rule. So this is guidance.
And I'm sorry, the page was again?
I'm on page 95 of the hearing bundle, my Lord.
Thank you.
Paragraph 41, we quote the guidance to which I've just referred. And it says the effect of section 20, ... of FSMA is that the regulated activities covered by an appointed representative's appointment need to, and it's the same point again, fall within the scope of the principles permissions. And paragraph 42, this is a rule. What do you have to do before you appoint an appointed representative? Well, you have to, and this goes back to the remarks I was making earlier about due diligence. You have to establish, if you're the AP, on reasonable grounds, and I emphasize that, you're not seeking a guarantee, you're seeking reasonable assurance that the firm has adequate controls over the regulated activities, adequate resources to monitor, and so on and so forth. The guidance we quote at paragraph 43 of our case goes back again to the idea that the permissions ought to, at the very lowest, be equivalent. The AR can't do something that the AP has no permission for, because it requires the terms of the contract to be designed to enable the firm to comply properly with any limitations or requirements on its own permission. And then there are two other, over the page at 96, there are two other rules from SUP that we quote, and our short point is the same about them both. A firm must take reasonable steps to ensure that each of its ARs does not carry out regulated activities in breach of the general prohibition. And we obviously emphasise the reasonable steps requirement. A firm should take, and the next one, a firm should take reasonable care to ensure that its AR has adequate arrangements in respect of training and competence. And the reason I draw attention to these is twofold. First of all, the Court of Appeal seems, with respect, to have reasoned that if, because the supervisory obligation exists, if the AR got something wrong, then that would lead to liability on the principal as the night follows the day. And that, we say, is not right, for the simple reason that those rules are studied full of the word reasonable, adequate, so on and so forth, so that it is conceivable that the client might suffer detriment as a result of the acts or omissions of the AR. The client might then come to the AP and say, well, you must have failed to supervise because something's gone wrong and I've suffered loss. And the AP could, on appropriate facts, defend the action successfully by saying, well, my obligation is not absolute. My obligation is to take reasonable steps.
So who's bringing the action in?
The action there would be by the client who has suffered loss as a result of the acts or omissions of the AR, but the AR has no money and no insurance. So the client goes to the AP and says, well, this situation must have come about because you've failed adequately to supervise, therefore I can sue you for damages. And that is so because under Section 1, in theory, because under Section 138D of the Act, breach of the rules made by the FCA is actionable on the same basis of breach of statutory duty unless the FCA has, in relation to specific rules, said no action shall lie.
How does that tie in with Section 39(3), which is, after all, what this case is about? I mean, isn't the liability under Section 93, as it were, an absolute one? Doesn't depend on...
It would be.
But why, in those circumstances, wouldn't the client just, as in this case, bring their proceedings under 39(3)? Why? I don't quite know why they'd be bothering with all this.
Well, my Lord, I won't take that too much further, save to point out.
But I mean, the point here is that presumably this could constitute a regulatory failure by the authorised person.
Yes.
So, I mean, these are clearly are obligations. Well, the rules are obligations and the guidance they have to take account of.
Yes.
And they may be held to account by the FCA for failures in that respect.
Yes. The reason I pick it up...
I mean, these are important provisions, aren't they? Because is it not in the SUP rules that one sees the legal obligation imposed on the AP to supervise
Yes.
the AR? I mean, those supervisory obligations are not spelt out, I think, in the primary legislation, although...
They are not, my Lord, no.
But you say that the SUPs are made pursuant to Section 137A, so
yes.
it falls within the rule-making power of Section 137A. But that's the real, is this not right, the real significance of these SUP provisions for our purposes, that there is this supervisory obligation imposed on the authorised person, and you say, well, it's very odd to impose a supervisory obligation on an authorised person to supervise something that AI is not permitted itself to do.
Just so, my Lord.
Yes.
And we also say, to put the point in a nutshell, that given that we have this supervisory obligation, it helps enormously in our discharge of it that we know what the AR is doing, or ought to be doing, because we can design our systems accordingly.
Well, you're obliged to.
Before.
Aren't you? I mean, you're obliged to. You've got to take proper steps to do it. How you do it is a matter of choice for you.
Yes.
But you've got to do it.
Yes.
I realise you're up against the time problem. But
yes.
Can you just help me on this? Am I right in thinking that the route to liability is from Section 39 through to Section 241?
Section 241.
Well, I'll have to find 241.
Which provides that a contravention of the prohibitions gives rise to an action for damages.
Oh, I see.
Does my Lord have a page for 241?
Well, I've picked this up from paragraph 30 of the Court of Appeal. establish in my own mind the route to liability, whether it does depend entirely on 39 or whether you also have to rely on 241.
Two 238 relates very specifically to a form of product, the unregulated collective investment scheme, which is, as you may know, a well-known, dangerous and sometimes toxic product.
Yes.
And what this, I think, says is that where there has been a contravention either in communicating or an invitation or inducement in relation to an unregulated collective investment scheme, that contravenes a prohibition in Section 238, which is specifically related to an unregulated collective investment scheme. And there is a separate section.
Sorry, red herring.
That's all right, my lord. I was going just to, perhaps I can.
But just going back to the point about what the purpose of the SUP rules is in this argument, when I read those, I was then slightly surprised, or your submissions, slightly surprised that it was accepted in the Court of Appeal that summary judgment would be given if you lost on this point, which suggests that it's not some kind of reasonable endeavours obligation, because, as my lord is right, if this is within Section 39.3, then however reasonable and thorough your supervision was, you can't get out of that. But the reasonableness and thoroughness of your supervision may be relevant to whether you're also subject to a regulatory penalty of some kind,
yes,
or investigation of some kind.
Yes.
Is that where we get to?
I think that's where we've got to, my lady, except that, sort of repeating myself, and although I take my Lord Richard's point that 39 might be an easier route, it is technically possible for an action to be brought against the principal for inadequate supervision, which leads to loss.
But that would be a fact that you couldn't possibly get summary judgment.
No. And in relation to what I've been saying about reasonableness of supervision, can I just ask the Court to note that that goes to paragraph 94 of the Court of Appeal's judgment, where, on one reading at least, it appears to have been assumed that if we had the obligations we did to supervise and a retail client was wrongly classified, that would automatically engage liability under the supervision rules, which is a proposition we don't accept. Well, I promised that I would look at.
So have you dealt with the equivalence point, or are you still coming?
No, that's the last thing I want to say, and I'm going to try and keep this as short as possible.
You can use up some of your reply time if you want to.
Well, my lord, in that case, perhaps I may do that, because I don't want simply to skate over it and
No, well, it's an important
yes,
point on which
yes,
I'd welcome assistance.
Yes. My lords, if I can therefore, and my ladies, if I can therefore end this part where I began, I made the observation that it is important that this system should work in an effective and useful manner, and the overall working of the system is critical to consumer protection. And I have cited, and I may possibly come back to it as the Lord indicates I might in reply, but I have cited a passage from the judgment of Lord Sumption in the asset land case, where he makes general observations in connection with consumer protection. Pertinently, he says two things. One, this is all a balance between regulatory overkill and, on the one hand, and detriment to consumers on the other. And he does make the point, in relation to which some of the other authorities my friends may take you to, need to be understood, that just because a transaction or class of transactions fall through the regulatory net in the sense, for example, that my clients are not liable for them, that does not mean that there is anything wrong necessarily. It's not the purpose of FSMA to provide a remedy in all cases to those customers who have suffered loss. Well, that, I think, ladies, takes me to where I am asked to stop. So unless there's anything else that I can assist you with at this juncture, I shall stop.
Part of the problem.
Sorry, I didn't mean to interrupt you.
Part of the problem here is also that the appointed representative is insolvent.
Yes.
And that is why they have to rely on their action against the principal.
Yes.
And why you, as principal, have no comeback against the appointed representative, or no valuable comeback, as you would contractually if they were solvent.
Yes.
But what is your supervisory role in checking their solvency, or anybody's supervisory role in checking their solvency vis-a-vis the nature or scope of the work that they're undertaking, or perhaps you don't have any?
We certainly have an obligation to check that at the outset of their appointment, because it's felt part of their being fit and proper. We do not know, I don't think, it's not in the evidence, what the accounts of either Jacob Hopkins McKenzie, who are the AR, or the SPVs through which this business has went, look like at any stage. And although the case is not put on the basis that these schemes were fraudulent, it is equally put on the basis that in some of these developments, not a spade was put in the ground, in a common and sorry term. It is also right to say, in answer to Milady, that sometimes appointed representative agreements require insurance, although, of course, that is commercial insurance, not, shall we say, the same as the minimum terms for solicitors, so it's always going to be open to an insurer to say not covered. And quite often in this sector, the network will hold a tolerably small policy and require the ARs to have their own policy, which is a sensible procedure, because if we have a Midas type situation where the AR has conducted himself thoroughly dishonestly, it is only that particular policy that will be avoided by the insurers. Whereas if everyone were relying on the central policy, and the lady has the point, again, the consumers might find themselves troubled by the insolvency.
Mr. Howarth, I may have misunderstood. I understood you to say that you had not completed your submissions in relation to the false equivalence point.
That's right, my lord.
And it was in that regard that I suggested that you might use up some of your reply time, that you're
Yes.
at liberty to do that, now to use up some of your reply time in order to deal,
Oh, I see. Right.
to deal with that point. Otherwise, Mr. Sims isn't going to be able to respond to it.
Well, my lord, I apologise for being dense, but that did occur to me. And I would certainly much prefer to complete.
Well, and we would prefer to hear from you at this point. So please feel free to use now
Yes.
some of your reply time.
Well, my lord,
If
I
that's
shall
appropriate.
I shall aim to, so to speak, get Mr. Sims on his feet by 1:30. So this is to be found in our case. Yes. We set out, first of all, and this starts at 96 in the hearing bundle, page 48 at the foot. And turning the page, in fact, to page 97 of the bundle, we introduce the idea that clients are classified in accordance with requirements in the COBS rules. At 50, we make the point, which is not in dispute, that the default classification is an eligible counterparty. Is a retail client. And a retail client is defined as a client who is not a professional client or eligible counterparty. And the professional client, first of all, can be per se or elective, and per se requires, so to speak, the boxes to be ticked in COBS 3.5.2R, and we set them out, and they are objectively ascertainable in brief. One either passes through these gateways or one does not. So, again, this is the genesis of our submission, that client classification doesn't require that much in the way of judgment. But I must acknowledge immediately, turning to page 99 and paragraph 54 of our case, that when one comes to an elective professional client, there is one part, and one part only, that requires an assessment. And that is to be found, if my lords and my ladies have the quotation in italic, at sub-rule 1, which provides that the firm, which is obviously my client, must undertake, quote, an adequate assessment of the expertise, experience, and knowledge of the client that gives reasonable assurance, in the light of the transactions or services envisaged, that the client is capable of making his own investment decisions and understanding the risks involved. And that is called the qualitative test.
Sorry, where do we see this?
Page 99, my paragraph 54, citation from the rule at subparagraph 1, if my lord has that.
Thank you.
Obliged. And coming to the rest of that rule, there's also a mandatory process that must be followed in addition. And one finds that at sub-rule 3, starting towards the foot of page 99. And effectively, to summarise, the client must say, I want to be treated as a professional client. The firm must say back to him or her, well, you must understand that you're going to lose protections and compensation rights if you, in the jargon of the industry, opt up to that status. And the client finally must come back, this is little c, and say, I am aware of the consequences of losing such protections. So, whilst there is an element of assessment there, there is also quite a lot of things that have to be done, as it were, prescriptively. And similar points can be made about an elective eligible counterparty, and this starts at 101 of the bundle. Quotation is towards the top, and indeed commences at the top. And to be an elective eligible counterparty, this again is pretty strict and doesn't require, we would say, the operation of any judgment. You have to be, as the client, an undertaking. That's the beginning of little 1. You have to be a per se professional client. In other words, this can be layered on the top of being a per se professional client. And you have to be a body corporate. That's little Roman 1. Or you meet the criteria on the 2 quantitative tests, quantitative, not qualitative. So again, this does not involve, we say, the exercise of any judgment. So that's why we submit that with the one small exception I acknowledge, this is a relatively mechanistic process. One contrasts that with what happens for suitability under COBS 9. And we start our discussion of this, paragraph 62 on page 101, assessing suitability of the obligations. Firm must take reasonable steps to ensure that a personal recommendation or decision to trade is suitable. How does one do that? Well, we turn the page and look at 2. You have to obtain the necessary information about the client, which includes knowledge and experience in the investment field relevant to the specific type of investment or service. And we say that that engages quite a lot of professional judgment in 2 ways. First of all, what's the necessary information? That will depend on the client. And what's the necessary information about knowledge and experience? Well, that depends on the specific type of designated investment or service. So we can see immediately here that there are 2 matters requiring quite a lot of judgment and assessment. Similarly, COBS 922R, a firm must obtain from the client such information as is necessary for the firm to understand the essential facts about him and have a reasonable basis for believing, giving due consideration to the nature and extent of the service provided. And I pause there because what's necessary to understand will be a client-by-client question. And it will depend on the nature and extent of the service being provided. And it involves, importantly, I mean, all of A, B, and C, in the list that follows, we would say, contain real elements of assessment and judgment. But B is perhaps the most important, able financially to bear the related investment risks consistent with his investment objectives. Now, that involves a calculus that requires you to understand the risks of the product, the nature of the client, and so on and so forth. My ladies, I won't go on.
So you could say that B requires them to know more holistically the financial situation of the client, whereas for a professional advisor, you don't have to inquire into how much money they've got generally.
No, and in fact, the only assessment you have to make in order to be an elective professional client is effectively that the client knows enough to make its own decisions without advice. Whereas by complete contrast, what we're looking at here in COBS is a whole lot of inquiries, considerations, assessments that have to be made in order for the advisor to provide suitable advice to the client, which is one of the key aims of COBS 9, which only applies to retail clients. And my lady, for your note, I effectively said that the only assessment involved in the elected professional client process was an assessment of whether the client is capable of taking his own decisions. And for the note, you find that in COBS 3.5.3R, which is quoted in paragraph 54 of our case, and in sub-rule 1, you have to have reasonable assurance that the client is capable of making his own investment decisions, so that he doesn't require advice at all. So, my lords, ladies, I hope I've said enough to support or at least explain our contention that these are chalk and cheese, and that the Court of Appeal was wrong to conclude otherwise. It's simply not the case that classifying client is just the same as or even close to the assessment of suitability. And so that is what leads me to submit with respect that there is a false equivalence in the part of the Court of Appeal's judgment where that proposition is relied upon. Unless I can help further, my lords, my ladies.
Thank you, Mr. Howarth. We're grateful. Thank you very much. Mr. Sims.
Just give me a few moments to rearrange the deck,
Yes, of course.
so to speak. Since lockdown, I've tried to wean myself off paper as much as possible, but it does sometimes require a little bit more time to adjust. My lords, my ladies, I think it's useful to start off our response to this appeal by pointing out at the outset what the focus of the appeal is. And the focus of the appeal is obviously section...
You might need to adjust the microphone.
Do you need me to...
in your direction.
shall I move across? So
No,
perhaps if you...
but you can move the angle of the microphone.
Okay.
That's better. Thank you.
I'm grateful. Yeah, so I was about to say the focus of the appeal is obviously on section 39, 1 and 3, and the proper interpretation of it. That interaction between exemption under section 39.1 and responsibility under section 39.3 is not actually determining liability. So it's about responsibility, and it's important to have that distinction firmly in mind. So it provides a gateway to potential liability, but it is not fixing liability. And I think there was some discussion this morning in relation to almost once you're within section 39.3, there's liability. That's not how it works. So the important point to understand is in order to establish a cause of action, you have to go through some other route in order to fix liability, which stands outside section 39.3. In this case, summary judgment was granted on two routes. One was through contraventions of certain COBS rules by reason of the fact that this was a collective investment scheme which was clearly prohibited and no one had actually the ability to operate it, and it should not have happened. So that was accepted as being a clear breach of the COBS rules. The second route through liability was to do with the promotion of that scheme, if you like, and responsibility for the promotion in relation to that. And I believe my Lord Lloyd Jones referred to the relevant paragraph, and that was in the Court of Appeal, paragraph 30, which referred to the statutory route through to liability, which then gets you into section 39.3. But I just wanted to make clear right at the outset that what we're focused on...
And what is the statutory liability for the promotion of the scheme then?
So it's dealt with in paragraph 30 of the Court of Appeal judgment, which is in effect via section 238, which is prohibition on communicating an invitation or inducement to participate in a collective investment scheme, save for certain exceptions which are not said to be applicable here. And section 240 prohibits an authorised person from approving, for the purpose of section 21, the content of the communication relating to a collective investment scheme. That person would be prohibited by section 238 from affecting the communication itself. And then section 241 provides that the contravention of those prohibitions gives rise to an action in damages.
But if this had not...
Sorry.
Yes, I think we're all want to say.
We're all asking.
So that's where I picked it up in paragraph 30. But that route applies because of the CIS point. Is that right?
Yes. So the starting point is a CIS point. So the route to liability at first instance in this case was because of the fact that these were collective investment schemes. So even though in the AR agreement it said there is no pooling, and it used phraseology to try and, in effect, treat it as if it wasn't a CIS. As a matter of substance, it was a CIS. and therefore there was the relevant contravention. It may all assist us to go just briefly back to the first instance judgment as well.
Well, it would assist. What if it wasn't this? If there hadn't been the CIS angle, what would have been the route to liability for
Just for retail clients.
just for retail clients?
You in that scenario, you might then potentially have an additional layer of argument to say you should, whilst you might have had permission to promote these to a certain type of client, you didn't to another. We did plead in our pleaded case an additional limb to our case, which was you're liable because these were CISs, and in brackets by way of parenthesis, either way, so to speak, because you misclassified certain people. That's an additional reason why this was something you shouldn't have been doing. But that was not what we got summary judgment on at first instance, that second aspect. So the reason why the retail client came into the reason why the retail client issue came into focus in this case was my learned friend took the point at first instance that we couldn't rely on section 39.3 as a gateway because he was saying we didn't assume responsibility for either CIS schemes or for dealing with retail.
So does it pull the rug out from under the 238, 240 and 241 if the retail, if Mr. Howarth is right about the retail clients?
It only pulls the rug out of a responsibility under section 39.3.
Yes, you can still pursue your common law.
Because there wouldn't be. Common law obviously is more restrictive in these circumstances than the statutory provisions. The statutory provisions provide you an additional layer of protection.
But does it mean you don't get into 238, 240 or 241 if you don't get through the gateway of 39.3?
Well, your problem is, as against a claim against the principal, is that they are not treated as being responsible for the actions of the appointed representative.
Yes.
So you have to establish, because the activity is being carried out by the appointed representative, not the principal. So you have to establish, in order to be able to have a gateway into liability against the principal, that they are to be treated as being responsible for those activities for the purposes of section 39.3. And the way through in that respect in relation to actually the specific activities in question in this case, the prescribed business activities were the questions of arranging deals in investments and advising investments under the RAO, the Regulated Activities Order. So I'm going to come back to that in due course. But what I wanted to make clear at the outset is that what we're not dealing with here is in effect, the secondary aspect of the case, which is liability having got into section 39.3. You still have to have an additional layer to your reasoning. Maloney Jr. has indicated that in the first instance judgment, the way this is dealt with is in paragraph 220. Page 220 of the bundle. So this is the first instance decision of Paul Stanley, KC, sitting as a Deputy High Court judge. And you can see that he deals with the Cobbs breaches allegations if we go back a little bit, you can see 219. He refers to the two cases we advanced. And he makes the point that I've just alluded to a few moments ago in paragraph 60. Section 39 imposes responsibility, not liability, which must be found elsewhere. So that was the brief point I was just seeking to draw your attention to right at the outset. Then he goes into the two cases that we advanced in the court below. So the first case is reliance on Cobbs, which he sets out, and then he looks at the two different periods in time in relation to that issue. and concludes that we should have summary judgment for the latter period.
And is there a provision in the Financial Services and Markets Act which says that a breach of the COBS rules is actionable as a breach of statutory duty?
So, as against the principle, yes. And so, yeah.
But the appointed representative is not authorised because they're exempt, and so
Yes.
they're not bound by the COBS rules.
No, it only operates in an indirect way against the appointed representative in the sense they get exemption, but the claim for breach of the COBS rules, the responsibility for compliance with the COBS rules is on the principal, the authorised person. But the cause of action, the right of action, is under Section 138D from memory. It's action in damages.
Thank you.
And I think just to explore the second element on which summary judgment was given, you can see that's then played out at paragraph 67 at the bottom of page 220.
Yes.
So again, the necessary link to the authorised person here, you can see in 67 little 3, was via section 39.3. So that was my first headline point really, was that the focus here is it's important that, yes, it's a gateway to liability, but it doesn't actually fix the liability itself.
But if, sorry, just to nail this down, if JHM had been solvent and the clients could have sued them, what would have been their cause of action against them?
In those circumstances, it would be contended that they, I think it's in relation to common law, it would be a common law cause of action in those circumstances.
It wouldn't be a breach of section 2.3.
It wouldn't be a statutory cause of action. The way the statute operates is to give the appointed reps, the AR exemption from the general prohibition, but your cause of action against the AR is in common law, not under the statutory provisions. And the way that you tend to formulate those arguments is to rely on COBS by way of analogy rather than direct application, because the formulation of the rules is vis-à-vis the principle, not the appointed representative.
Right. So the action against the appointed representative is under common law, and if you can establish that, as you say, perhaps relying on COBS by way of analogy as to what the standard of the reasonable advisor should be, then the principal can be liable for that. The principal may also be liable separately for its own breaches of COBS rules separate from section 39.3, but then one gets into the question of whether they were in breach given that the COBS rules are expressed as reasonable standards.
But the authorised person is responsible and potentially liable not only for their own direct potential breaches of the COBS rules, but by the gateway of section 39.3, they are treated as being, those breaches are treated as their breaches for the purposes of the appointed representative. So that the way the rules operate is that they are deemed as...
Who is deemed?
The authorised person. So if we go back to section 39, and look at section 30.
Oh, I see. So if the appointed representative does something which is not a breach by them of the COBS rules because they're exempt, so they're not bound by the COBS rules, but if that had been done by an authorised person, it would have been a breach of the COBS rules, then the authorised person the principal is liable, is that?
They're treated in effect as breaches by the principal.
I think they're treated as actions by the principal,
Yes.
which has the corresponding.
Treated as breaches.
Sorry, did I misunderstand your question? Were you talking about the situation where the appointed representative is exempt or not exempt?
Is exempt.
Well, they're exempt, yes.
Yes. So when they're exempt, the way that the statute operates is to treat. Perhaps if you go just look at section 39 and just get section 39 in, within plain sight. So it's probably easiest for us to do that by reference to where it is in the authorities section of the bundle. And I don't think we've probably yet gone to it, so it's probably useful for us to do so.
911.
Yeah. And the way that obviously the focus for the purposes of the argument in relation to the ambit of exemption starts with section 39.1. We then have section 39.1, section 39.3, which starts at page 913. You get just above that the definition of appointed representative. A person who is exempt as a result of subsection 1, or a person carrying on a regulated activity. So in circumstances where certain provisions don't apply. And then we have little 3, the principal of an appointed representative is responsible to the same extent as if he'd expressly permitted it for anything done or omitted by the representative in carrying on the business which is accepted responsibility. And then in addition, in subsection 4, in determining whether an authorised person has complied with any provision contained or made under this Act, anything which a relevant person has done or omitted, and so I'm reading to the tailpiece of subsection 4, anything which a relevant person has done or omitted as respects business for which the authorised person has accepted responsibility is to be treated as having been done or omitted by the authorised person. And then the definition of relevant person is appointed representative. So the way that the statutory scheme operates is to attribute to the authorised person the acts of the appointed representative.
And if the principal, had he done those things, would have been in breach of a COBS rule, and that's a COBS rule that confers a cause of action.
Exactly.
Then he is so liable for that breach, even though actually the appointed representative hasn't breached a COBS rule because they're exempt and not bound by COBS rules. Right.
Technically, that's right. So the way that the statutory scheme operates is to in effect collapse the appointed representative into the authorised person for the purposes of fixing liability onto the authorised person.
I mean, my lady refers to the COBS rules. But in this case, am I right in thinking, I think this is what you told us, that liability was imposed by virtue of sections 2, 3, 8 and 240
yes.
of the Act?
Which, and so in effect there was
read with
section
138D or whatever it is, section 241 and 138D.
Yes, it's back to the paragraphs we were looking at a few moments. So more precisely, I suppose it may be said that there was overlapping summary judgment for a lesser part, but because the judge granted summary, he in effect accepted our arguments on COBS for part of the period.
Oh, did he?
As well. So and then he accepted our arguments in relation to the promotions route in toto.
I I see.
So that was our route through to liability at first instance, and our route through to that was on the basis that, in effect, you, the authorised person, has put the AR into the situation of advising and arranging, promoting, selling these schemes to us, and you should be treated as responsible, as if they were your own acts for the purposes of Section 39.3. And so the ultimate, the reason why I was wanting to just take a step back is because often you see reference to liability, in effect under Section 39.3, but it's not a direct, there's an additional step required. It's responsibility technically rather than liability. So they're treated as responsible, and under Section 39.4 there's attribution, both not just in relation to civil but also regulatory consequences. So the beneficial effect of that vis-à-vis consumer protection is that the investor has protection vis-à-vis wrongs as against a more substantial entity, long-stop entity at the end of the chain, in effect. And they are treated as responsible for the actions of the person they've in effect put into the regulated activity sphere via an exemption process. So that was my first point, was really just to sort of emphasise that point. The second point was
I think this was raised with you, but could what claim would the investor have against the AP? No, the AR, the appointed representative.
So they're technically not bound by the COBS rules. They're exempt.
And nor are sections 238 and 240 relevant to them.
Exactly. They're exempt. They're not. This passes over them.
What civil remedy?
Your only way to do that would be to say to a judge, well, by analogy, they're put into this position by analogy on a basis of a sort of common law cause of action, saying, well,
what, in negligence or what?
It would be a tortious claim, yes.
Well, I know, but what sort of tortious claim?
In negligence, yes.
But that would require showing that there was a breach of a duty of care in relation to the content of the.
It would require the court to accept that there was a sufficient proximity.
Yeah, but I mean, the liability under 238 arises simply by virtue of communicating an invitation to participate in a collective investment scheme, which results in loss. So presumably it's enough to say, well, if you hadn't sent me this invitation, I wouldn't have accepted it, and I wouldn't have incurred the loss I've now incurred. You don't have to show it's a false prospectus or anything like that.
As against the principle,
correct.
You're having to show that there was a contravention by reason of the fact of them promoting a collective investment scheme,
yes,
which they were not entitled to do.
Yes.
So there's a more direct, simpler route, if you like, through as against the principle than there is on this set of facts as against the AR.
You've got to show some.
As against the AR, you have to show some common law nexus,
deceit or
a duty of care in tort, or perhaps that in certain circumstances there may be some contractual relationships.
But would the AR be committing an offence?
So that's the key point, really, which is that if they are acting outside their exemption, then the AR is committing a criminal offence.
Which necessarily it would
I should say, in relation to regulated activities. All of what I say is in the context of regulated activity. Obviously, if it is not a regulated activity, it's not a contravention of Section 19, the general prohibition. But that's the problem with respect, which my learned friend has not really addressed in this case, which is that this case is not about a situation where the authorised person entered into arrangement with an appointed representative to encourage them to do something which under the statutory scheme, they should have been doing. They positively said, we want you to only deal with non-retail clients in this context. So contractually, that's what they were trying to achieve. The real question for this court is not whether or not they were entitled to do that, or indeed should have been doing that as a matter of a positive obligation under the various sub-rules, but what the consequences are where they make a mistake in relation to that, which is a mistake which is very easy to make. And
who made a mistake, sorry?
The appointed representative in relation to client classification. Every single case has a client onboarding process where you have to assess what the client is to be classified as. Frequently, when you come to that...
Are you saying... I hadn't picked this up, I'm sorry.
Yes.
So what the judge found, did he, that that in this case the AR believed all these clients to be professional clients, not to be retail clients?
That's how they were. That's how they were identified in all their material. Perhaps I should take a.
Sorry, no. Just so. I mean, as I understand it, they are, and it's accepted that they are retail. Well, with one exception, retail clients.
There's a slight more complexity than that. It's one wasn't even in fact classified.
I appreciate. That's why I said
yes.
With one exception.
So yes. And it's curious the way this evolved.
I thought, Mr. Sims, sorry.
Yes.
My reading of the judgments below, that they proceed on the basis that all bar one of the claimants were retail clients.
Were misclassified, yes, because that's...
So, first of all, they were retail clients. Before you get on to misclassification.
So the way that this point arose was slightly curious because we pleaded out, and I can take you to the schedule, you're probably aware of the schedule, the various different client classifications. My learned friend didn't admit that in their pleading, but then sought to adopt a positive position in response to our summary judgment application to say, well,
they were retail clients.
They were retail clients. So there's no formal document from them in terms of their pleading where they said that, but in fairness to my learned friend, he was thrown into
But I'm sorry, Mr. Sims,
yes.
just to cut it short.
Yeah.
We're here because the claimants are
contending
presumed to be retail clients. Isn't that right? Yes. We wouldn't be here if they weren't retail clients.
No. Look,
is that right?
Yes, say for two.
Then you talked about misclassification. Are you saying that the judge found, on the summary judgment application, that the AI misclassified them, believed that they were professional clients and didn't realise they were retail clients? Is that what?
Well, there was no evidence directed at that point. It was just.
Well, you said they were misclassified. I was just trying to understand whether that's part of the factual background of this case or not.
They must have been misclassified because
Why do you say that?
Because if the factual contention which has been pleaded by us is this is the designation this is the client classification you gave to various of these people, and
is that what was the classification? They were professionals.
Yes, exactly. That they were professionals. Yes.
Oh, I see. That's
Sorry, is that
you pleaded that the AI classified them as professionals. Is that right?
Exactly.
Okay. Sorry. Well, sorry to have taken.
Exactly. Sorry for the cross purposes. It may assist for me just to take you to the schedule where we pleaded out the being incorrectly classified, and that's at I think it's at page 26. Is it?
Sorry, I can't hear you.
Sorry, I'm just checking to see whether I've got the right page reference for my junior on the. No. Where this is dealt with is within the appendix, and it's 260.
260.
I see. I see.
So the factual scenario we're dealing with here was not an AR going off purporting to do something which they were prohibited from doing under the AR contract, if I put it that way, in this sense, in the sense of consciously intending to do that.
Well, we don't know, do we?
No, we don't know that, but they were misclassified. They were classified in the internal documents for.
Yes, I follow that.
Yes.
Yeah, thank you.
So for the purposes of, just to assist one further point whilst we're on this topic, it's worth perhaps just looking in terms of the internal documents just to see how this process works, because it's a process. It's a common process. In fact, wouldn't be overstating to say it's a universal exercise that will be required to be carried out as part of the onboarding exercise, is to actually look at the position vis-à-vis what the client should be treated as. And if, for example, we look at back into some of the Appendix 7 documents a bit later on from this, at, for example, some sample documents behind little tab 10 at page 286. So this is an example of one of the claimants or respondents, Mira Shah. I'm afraid, again, the documentation is not always complete in relation to these documents, but you can see that near the end of the little section of notes after the signed letter, which concludes at 289, we then have a signing up by this particular person, Mira Shah, at page 290, electing to be treated as a professional.
Well,
And
we don't, sorry.
We don't know how this came.
We just don't know whether this was a genuine or reasonable position taken by the AP, do we? To be frank, if I express my own view, it's very surprising indeed that these people were classified in the way they were, but we have no, on the face of it, but we have no details about this at all. We just don't know what went on there.
No, what I suppose I'm trying to show you is more a point to do with the process. That this is a process which has to be undergone in relation to each client. We don't need to get into the detail as to the rights and wrongs of whether or not this was obviously wrong or not for present purposes. And there will be a range of cases. There'll be a range of cases where some are obviously wrong, some may be more difficult to assess, some may be right. For example, one of them was identified as being right. And the oddity we end up then is on my learned friend's case, is the one person who's classified correctly is the one person who is able to maintain their judgment. And that's a point we'll come back to in due course. But just to do
a convenient point.
Sorry?
Maybe a convenient point.
Yes. Thank you.
Thank you, Mr. Sims. We'll resume at 2 o'clock. We will have until 3:45, and Mr. Howarth will have 15 minutes.